This is Hindsight Radio. I represent it. The information station changing the nation. Hindsight Radio, the place for right knowledge.
Peace, everybody. This is your host, Akeem L. from Hindsight Radio, the information station, changing the nation. Man, that's my new intro that my brother did that. Truzilla, a.k.a. Paul Barber. He did that. He hooked me up on that. So I sent him some love, a monetary donation for that. You know, we always got to support our family, right? First and foremost. Blood come first. Everything else comes second. All right. What am I here doing here? I got this case up called Cross versus Board of Supervisors of Elections of Baltimore City. This case took place in September 1966 in the Court of Appeals of Maryland. This has to do with the United States and the separation from the state and the United States. This case gives clear distinction between the two and the citizenship between the two. This guy was running for sheriff, and they tried to say he couldn't run for sheriff because he had just become a U.S. citizen. He wasn't a U.S. citizen long enough, and he could not be run for that office. But there's some profound information found in this case. There's so many cases like this, but I'm reading this one because it's got something in here. It got a jewel in here that you could use to shut down any case. Now, remember, when you guys are using case law, you got to use, cases that went to the appeals and was decided. A lot of people are using case law that has not went to the Court of Appeals and was decided. That's when you use case law. Because what happens, a case goes before someone and then they disagree, they go to Court of Appeals, and then the appeal court decides or make a decision to affirm or the case, or not agree with it. Is another term they use for that. And as usual, I got to tell you, this is not legal advice. I'm not a lawyer. I'm just someone who likes to read and share information to help you help yourself. So you don't have to put all that bread out to get somebody to screw you. But anyway, all right, here's this case. And this case can be used in a lot of cases. Child support, IRS cases, that, in my opinion, it's got so many ways you could use it. Well, let's start off here. The cause was argued before Hammond, Horney, Marbury, Oppenheimer, and Barnes, J.J., St. George, I.B., Cross, third, improper person for appellate. It said improper person. And you notice how the stylings are all properly styled. Edward L. Blanton, Jr., Assistant Attorney General, with whom was Thomas B. Finnan, Attorney General, on the brief for appealee. Decided per Coriam, July 1st, 1966. Oppenheimer J. delivered the opinion of the court, and they put him in all caps. All right, indicating that's, although a living person did this, they put it, as a entity. Okay. After argument by per coriam order, we reversed the order of the Superior Court of Baltimore City, which denied the appellant's petition for a writ of mandamus to compel the Board of Supervisors of Elections of Baltimore City to accept and certify his candidacy for sheriff of Baltimore City, in order that the mandate directing a writ of mandamus prayed for below be issued forthwith. The reasons for our order follow. The question involved is whether the appellant is qualified to become a candidate under the provisions of Article 4, Section is that 4? Yeah, 4, Section 44 of the Maryland Constitution. The material provisions of that section are as follows. There shall be elected in each county and in Baltimore City one person resident in said county or city above the age of 25 years and at least 5 years preceding his election, a citizen of the state to the office of sheriff. So it says citizen of the state, right? Not United States. The facts are not in dispute. The appellant was born in the West Indies and immigrated to the United States in June of 1957. He and his family established their residence in Crisfield, Maryland. Upon reaching his 18th birthday and upon signing his declaration of intention to become a citizen of the United States under the federal naturalization law, he enlisted in the United States Army, served for approximately 3 years, and was given an honorable discharge in 1960. He established his residence in Salisbury, Maryland, and matriculated at the Maryland State College, from which he was graduated in 1964. He then entered the University of Maryland Law School and has successfully completed his first year. In May of 1964, he established his home in Baltimore City, where he has since resided. On April 29, 1966, he became a naturalized citizen of the United States and a registered voter of the state of Maryland. On May 26, 1966, the appellant filed his candidacy for office of sheriff of Baltimore City with the Board of Supervisors of Elections of Baltimore City. His certificate of nomination was notarized and accepted, as was his filing fee of $150. He received the usual material given to all candidates who file for public office. On June 4th, 1966, he received a letter from the board advising him that he did not qualify as candidate for the office of sheriff because he did not become a citizen of the United States until April 29th, 1966. At that, under the 14th Amendment of the United States Constitution, he did not become a citizen of the state of Maryland until that date. The board acted on the advice of its counsel, the Attorney General of Maryland, and returned the application to the appellant together with the filing fee. So the counsel gave these people saying he don't qualify. They don't know how to read their own rules. Here we go. The court below held, and the board contends, that the appellant did not become a citizen of Maryland under the provisions of the Maryland Constitution until he became a citizen of the United States, and is therefore ineligible to be sheriff of Baltimore City because he was not a United States citizen at least 5 years preceding the election. We disagree. Here's where the information is starting to flow. Both before and after the 14th Amendment to the federal Constitution, it has not been necessary for a person to be a citizen of the United States in order to be a citizen of the state. Now, you notice how they got United States up alone, then they got citizen of a state, all lowercase, indicating sovereignty, right? United States v. Cruikshank, 92 U.S. 5459. That's another case that came before that talks, uses the same language. And that was a civil rights case. 1875 slaughterhouse cases, 83 U.S. 16 Wall 3673-74 1870. And I'm not going to read all those cases, but I'm going to just skip over to this part. Citizenship of the United States is defined by the 14th Amendment and federal statutes, but the requirements for citizenship of a state generally depend not upon definition, but the constitutional or statutory context in which the term is used. Ryswick versus Davis and all of these other cases, and authorities therein cited. The decisions illustrate the diversity of the term usage in Phil v. Adrian 7 MD 209 1854. I suggest y'all read all these cases. Our predecessors held that an unnaturalized foreigner residing, turn that down. Okay, unnaturalized residing and doing business in this state was a citizen of Maryland within the meaning of attachment laws. The court held that the absconding debtor was a citizen of the state for commercial or business purposes, although not necessarily for political purposes. Dorsey v. Cal, 30 MD 512 518 1869. Is to the same effect. Judge Alvey for the court said in that case that the term citizen used in the formula of the affidavit prescribed by the 4th section of the article of the code referred to is to be taken as synonymous with inhabitant or permanent resident. Other jurisdictions have equated residence with citizenship of the state for political and other non-commercial purposes. In Willets 16 WIS 443446 1863 held that the Wisconsin statute designating all able-bodied white male citizens as subject to enrollment in the militia included an unnaturalized citizen who was resident of the state. Under our complex system of government, the court said there may be a citizen of a state who is not a citizen of the United States in full sense of term. McKenzie v. Murphy, 24 ARK 155 159 1863. So it just says plainly that you could be a citizen of a state, but not a citizen of the United States. Now, let me be clear. I'm not advocating being a state citizen at all, because they have since updated these constitutions to say every citizen of this state owe allegiance to the United States. So they put a hole in that. Held that the alien domiciled in the state for over 10 years was entitled to homestead exemptions provided by the Arkansas statute to every free white citizen of this state, male or female, being a householder or head of a family. The court said the word citizen is often used in common conversation and writing as meaning only an inhabitant, a resident of a town, state, or county without any implication of political or civil privileges. And we think it is used in our Constitution. Hallaby v. Board of Directors of University, Supra, involved the application of statute which provided free university instructions to citizens of the municipality in which the university is located. The court held that the plaintiff, an alien minor whose parents were residents of and conducted a 560 business in the city, was entitled to the benefits of that statute, saying it is to be observed that the term citizen is often used in legislation where domicile is meant and where United States citizenship has no reasonable relationship to the subject matter and purpose of the legislation in question. Closely in point to the interpretation of the constitutional provisions here involved is a report of the Committee of Elections of the House of Representatives made in 1823. A petitioner had objected to the right of a delegate to retain his seat from what was then a Michigan territory. One of the objections was that the delegate had not resided in the territory for 1 year previous to the election in the status of citizen of the United States. An act of Congress passed in 1819 provided that every free white male citizen of said territory above the age of 21 years who shall have resided therein 1 year next preceding an election shall be entitled to vote in such election for delegate to Congress. An act of 1823 provided that all citizens of the United States having the qualifications set forth in the former act shall be eligible to any office in the territory. The committee held that the statutory requirement of citizenship of the territory for a year before the election did not mean that the aspirant for office must also have been a United States citizen during the period. The report said it is the person, the individual, the man who is spoken of, who is to possess the qualifications of residence, age, freedom, etc., and at the time he offers to vote or is to be voted for. Upon the filing of the report and the submission of resolution that the delegate was entitled to his seat, the contestant of the delegate's election withdrew the protest and the sitting delegate was confirmed. Biddle v. Richard, Clark and Hale, cases of contested elections in Congress, 1834, 407, 410. There is no express requirement in the Maryland Constitution that sheriffs be United States citizens. Whoa. Voters must be under Article 1, Section 1, but Article 4, Section 44 does not require that sheriffs be voters. A person does not have to be a voter to be a citizen of either the United States or of a state. Notice how they capitalize. As in the case of native-born minors. In Maryland, from 1776 to 1802, the Constitution contained requirements of property. Ownership for the exercise of franchise, there was no exception as to native-born citizens of the state. Steiner's Citizenship and Suffrage in Maryland, 1895, 2731. The Maryland Constitution provides that Governor J. Judges and the Attorney General shall be qualified voters and therefore by necessary implication citizens of the United States. Article 2, Section 5, Article 4, Section 2, and Article 5, Section 4. The absence of similar requirement as to the qualifications of sheriffs is significant. Listen very carefully. So also, in our opinion, is the absence of any period of residence for sheriffs except that he shall have been a citizen of the state for 5 years. The governor, judges, and attorney general, in addition to being citizens of the state and qualified voters, must have been a resident of the state for various periods. So what they're saying, sheriffs fall up under a different requirement. And as I keep reading, you'll see what it is. Because you got to remember, sheriff is the law officer of that county, right? He is the supreme officer to enforce the law, serve out petitions, make sure people get served, when judgments, enforce judgments. You get name change order. He can enforce that, right? You got a judgment. They not abiding by it. Okay. Here we go. So I'm hinting y'all. The governing judges and attorney generals to be a citizen of the state and qualified mother must have been a resident of the state for various periods. The conjunction of the requisite period of residence with state citizenship in the qualifications for sheriff strongly indicates that is in the authorities above referred to. State citizenship as used in the constitutional qualification for this office was meant to be synonymous with domicile, and that citizenship of the United States is not required. Even by implication, as a qualification for this office, the office of sheriff under our Constitution is ministerial in nature. A sheriff's function and province is to execute duties prescribed by law. And these all are the case laws after that. Here we go. It may well be that the phrase a citizen of the state as used in the Constitution provisions as to qualification implies that a sheriff cannot owe allegiance to another nation. Let me read that again. Okay. It may well be that the phrase a citizen of the state, and you notice how state is capitalized, as used in the constitutional provisions as to qualification implies that a sheriff cannot owe allegiance to another nation. So a sheriff, as he's holding that office, along with his deputies, are not citizens of the United States because they cannot owe allegiance to another nation. So any problems you got, you need to be stepping to the sheriff. By the Naturalization Act of 1779, the legislature provided that to become a citizen of Maryland, an alien must swear allegiance to the state. The oath of affirmation provided that the applicant renounce allegiance to any king or prince or any other state or government. Whoa. Act of July 1779, Chapter 6, Steiner, Op. Cite 15. In this case, on the admitted facts, there can be no question of the appellant's undivided allegiance. The court below rests its decision on this conclusion that under the 14th Amendment, no state may confer state citizenship upon a resident alien until such resident alien becomes a naturalized citizen of the United States. The court relied, as does the board in this appeal, upon City of Minneapolis v. Ruum, 56 Fed 576 581 8 Circle 1893. In that case, an alien resident of Minnesota who had declared his intention to become a citizen of the United States but had not been naturalized brought a suit based on diversity of citizenship against the City and Circuit Court of the United States for the District of Minnesota under Article 3, Section 2 of the United States Constitution, which provides that the federal judicial powers shall extend to the controversies between a state or the citizens thereof of the foreign states, citizens or subjects. At the close of evidence, the allegation that the plaintiff was an alien, the court denied the motion. The plaintiff recovered judgment, and the defendant claimed error in the ruling on jurisdiction. The Circuit Court of Appeals affirmed. Judge Sanford for the court stated that even though the plaintiff was a citizen of the state, that fact could not enlarge or restrict the jurisdiction of the federal courts over controversies between aliens and citizens of the state. The court said it is not in the power of a state to denaturalize a foreign subject who has not complied with the federal naturalization laws and constitute him a citizen of the United States or the state so as to deprive federal courts jurisdiction. So, whoa, that says something else. Your state can't confer citizenship on you as a United States citizen. They can't do it. That's why they want you to check off these boxes when you go to get their documents, because you confer it on yourself by checking them off. But if you're reading this carefully, if you understand what I'm saying, you got to go take an oath to be a citizen of the United States. Now, this brother, he did all of that. He did all of that, to be a citizen because he thought, make it, that's what he wanted to do. He thought that was the right thing to do. But they're telling you, they're two distinct citizens. They're different, and you can be one or the other, or you could be both of them at the same time. But what's stunning in this is that a sheriff can't be a U.S. citizen as long as he's holding that office. He is solely, wholly commissioned and constituted under the constitution of that country, that state that he's working for, that county. That's his whole jurisdiction. Whoa. That says a lot. That says a lot. I hope y'all grasp that. For real. That's why I read it, so y'all can see that there's more remedy. You know, this actually helped me. I'm working on a situation now where they asking this guy for discovery, you know, the child support thing, and they using them all cap names and all of that stuff. And they see they trying to confer U.S. citizenship on him. How? Oh, Akeem, how was he doing that in child support? Yeah. How? Because all child support statutes that they see of the state are enforced under the federal statutes. You see? So he has to show that he's not in their jurisdiction. I'm reading this. I'm like, yo. So I'm going to give him my spiritual advice on that from a spiritual point of view. That's how I help people through spirituality. That's my God in me, God-given right. So there you go. Y'all can keep reading the rest, read the other cases, but it was so many others that I read, but I like this one because of the sheriff part. Y'all got power. Y'all got court orders with name change. Y'all going in there. They don't want to change it. You know what I'm saying? Oh, yeah, I forgot this. I can't leave without giving y'all this. Let me type this in. Hold on. It is 18 U.S.C. 1001. I know y'all, they out there trying to keep up with me. They can't. I've been stockpiling. I've been preparing for this day. They can't keep up. They will never. The ancestors are solely and wholly on my side at this time, long as I'm obeying the God in me. And you need to do the same. Here it is, 18 U.S.C. Statements or entries generally. Oh, Akeem, why are you reading this? What does this mean? What is all this? A, except as otherwise provided in this section, whoever in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a material fact, makes any materially false, fictitious, or fraudulent statement or representation, or makes or uses any false writing or document knowing the same to contain any materially false, fictitious, or fraudulent statement or entry, shall be fined under this title in prison not more than 5 years, or if the offense involves international or domestic terrorism, in prison not more than 8 years, or both. If the matter relates to an offense under Chapter 10A, 109A, 109B, 110, or 117, or Section 1591, then the term of imprisonment imposed under this section shall be not more than 8 years. Okay? You can keep reading the rest. So why am I reading that? When they put them names and all that stuff, you got the IRS sending you stuff with that all caps. That's fictitious tricks, schemes. It's not you. So you got to put these people on notice. You got to send that stuff off to the commissioner. You got to send that stuff off to the commissioner, the SSA. All these top dogs, Department of Justice. You got to let them know, hey, y'all, this is who I am. Please do not send me nothing, anything other than my proper name. Okay? Proper Christian name, whatever you want to call it. All right. There you have it, y'all. Peace.